welcome. Please,
Well,
you can present yourself.
thank you very much indeed. It really is a pleasure to be with you this evening. Unfortunately, not in person as had been originally planned, but nonetheless, a pleasure to join all of you at MIFF and revel in the incredible work that you're doing. And I'm very grateful for the invitation. I am a practicing lawyer in London. I also have the great honor to be a director of an organization called UK Lawyers for Israel, a voluntary organization of lawyers working really to advance the proper and objective application of law to Israel, citizens of Israel, supporters of Israel. We use the law against attempts to undermine, attack, and delegitimize Israel and Israeli organizations. And one of the areas that UK LFI contends with is misrepresentations of international law vis-à-vis Israel. You'll often hear that Israel violates international law. The accusation is thrown around without basis or justification. But the difficulty, I believe, is that many people don't know very much about international law. It's quite a mysterious concept. And so it can easily be misrepresented in relation to Israel. It's also an area in which politics and law overlap and where a special language of condemnation has evolved in relation to Israel. Illegal settlements, inextricably linked with illegal occupation. These are unique terms in respect of their use to Israel, and they are contrary to what international law actually says. So I've been asked to address the status of Jerusalem and settlements in international law. And over the next 40 minutes, I propose to cover what international law tells us about the legal status of the territory. I'll look in particular at Jerusalem. I'll look also at the settlement issue. And finally, by way of example, I'll look at the recent controversy over Israel's proposal to apply Israeli civilian law to parts of Area C in the West Bank, which has been incorrectly termed annexation. But first, for the non-lawyers in the room, of which I appreciate there must be many, international law is very different to domestic law, with which we're more familiar. There is no international parliament which sets down international law for us all to follow. It's a body of rules that has been established according to a number of key sources. And I'll mention the two main ones. The first is treaty, and that is quite like contract law. So it involves states making written agreements between themselves, bilateral treaties or multilateral treaties if many states join together, or perhaps they sign up to a convention. And that is law that states sign themselves up to and bind themselves to. But another source of international law is custom. Now, customary international law, customary legal principles, they can develop over time, and they evolve when sufficient number of states behave in a particular way, believing themselves to be legally obliged to behave in that way. And then we say that over time, we see a principle of customary international law emerging. Now, that source of international law is important because I'm going to be talking about a key principle of customary international law in relation to the status of the territory of Israel. Before we get on to that, just to clarify a big misconception, especially in terms of the debate about international law in Israel, and that is this idea that UN resolutions have legal force. Now, these are, for the vast majority, political tools as opposed to legal ones. Resolutions of the General Assembly have no legal force whatsoever. They are purely political. Resolutions of the Security Council are for the most part also entirely political. The legal status of a UN Security Council resolution is determined by the chapter of the UN Charter under which it's made. And the vast majority are not made to be legally binding, simply because diplomatically, politically speaking, it's much easier to pass a resolution that doesn't have legal teeth. In order for a UN Security Council resolution to be legally binding, it has to be passed under Chapter 7 of the UN Charter. And these are incredibly rare. Such a resolution is immediately binding on all member states. They often require military intervention. And I'll give you just a couple of examples. Resolution 678 in 1990, with respect to Iraq, the Security Council gave Iraq a set period to withdraw from Kuwait, and it empowered states to use all necessary means to force Iraq out of Kuwait after the deadline. And Security Council Resolution 1373, in response to the 9/11 attacks, that was famously made under that Chapter 7 rubric, so as to be binding on all member states. But if a resolution isn't made under Chapter 7, it's automatically made under Chapter 6 of the UN Charter. And those resolutions, unless they meet very specific criteria, which classes them as decisions, they simply don't have legal force. And it's something to bear in mind, I think, when you're discussing international law in relation to Israel. Now, the essence of this talk is the status of the territory in international law. And as I indicated, there is a fundamental principle of customary international law that establishes the borders of newly emerging states at the moment of independence, so in Israel's case, in 1948. It's a universally applied principle. It developed throughout the 19th century. It was applied in South America. It was later applied in Asia and in Africa, and still later at the disintegration of the former communist federations. And it's been applying to all of the states that emerged in these cases, and also, crucially, to states emerging from former mandates. For example, the mandate for Mesopotamia when it became the Kingdom of Iraq, mandates for Syria and Lebanon, and really in all cases involving mandates, this was the default rule for those states emerging in terms of what their borders would look like. Now, this universal rule for determining these borders applies at the moment of independence, at the critical date of independence. And when the International Court of Justice talked about this principle, it talked about it in terms of a photograph of the territory at the critical date of independence, and that determines the international boundaries according to the pre-existing administrative boundaries of the entity that this state is born from. The rule is called uti possidetis iuris, and it's a default rule, so it applies where there's no agreement to the contrary. It's been applied and it developed to afford certainty in situations where matters can be uncertain when new states are coming to existence. It was applied to avoid frontiers being challenged by neighbouring states, to avoid wars breaking out, and to promote peace and security. Those are the reasons the International Court of Justice recognised as being behind the development of this principle. Now, another fundamental principle of international law is its equal application. You cannot have a general rule and an exception for a country that you just don't like very much, or you have some political or ideological opposition to. That is not how any respectable legal system can operate. So the question must be, why does this principle universally applied, or in fact, what does this principle universally applied tell us about the legal status of the territory in Israel's case? And if it's not being applied, why not? So, firstly, what does it tell us? Well, in 1948, the administrative lines of the eastern side of the British Mandate ran along the Jordan River. And I'm going to beg your indulgence for a moment while I share my screen to be able to show you exactly what it is that I'm talking about. Because here we have the British Mandate after the severance of Transjordan. And this was the eastern border that you can see, the Jordan River running all of the way down to the Red Sea in the south. This was the landmass, the British Mandate for Palestine, that the State of Israel emerged from. And the question the principle tells us to ask is how many states emerged from this territory at the critical date of independence. And if the answer is that in 1948 it was only the State of Israel that declared independence, then the principle tells us that Israel inherits the pre-existing lines of the British Mandate as its internationally recognized borders. And now I can, I hope, stop my screen share. So that was the line originally dividing the mandate from the separate administrative unit of Transjordan. It later became the Hashemite Kingdom of Jordan. And by the way, Jordan's borders also followed the principle of uti possidetis iuris when it came into existence. Now, Israel, as I indicated, is the only state to emerge from that territory in 1948, automatically assumes under this principle, as its internationally recognized borders, the administrative lines of the mandate. And as you saw on the map, that includes East Jerusalem and the West Bank, which was occupied by Jordan between 1948 and 1967. These same areas were recovered by Israel in 1967. The legal status of the territory, therefore, applying this principle, is that Israel has been sovereign there since 1948. There has been no agreement of any kind on the transfer of sovereignty. And just remember that this principle applies as the default where there has been no agreement. The legal status is important because it tells us that Israel's presence in the territory is entirely lawful. And crucially, it is not a situation of occupation. That is another misrepresentation. The framework of the law of occupation developed in customary international law not to protect the rights of ordinary people. In fact, it developed to protect the rights of a former sovereign during a period in which it had been ousted from its territory. So, even if one were to quibble with the application of this universal principle, uti possidetis iuris, and reject its application to Israel, and I indicated that the key question here would be to ask, why are we rejecting it in Israel's case when it's universally applied? And I have found no good answer for that. But if we were to say it doesn't apply, there is no other sovereign who has been ousted from their territory which could trigger the proper application of a situation of occupation. So the occupation framework in which we apply the Geneva Convention does not work where there is no sovereign from which Israel acquired the land. And I indicated Jordan, which controlled the territory before 1967, was an occupier of that territory under international law. It was not a legitimate sovereign. And of course, it did not comply even with the international law under occupation when it ethnically cleansed Jerusalem and the West Bank of its Jews after the War of Independence. Crucially also, the occupation framework doesn't apply after a peace agreement. Again, it's a point that not many people raise, but it did feature in the famous US Hansel memo on settlements that was recently revisited by Secretary of State Pompeo. Crucially, the peace agreement between Israel and Jordan in 1994 would, in any other context in international law, put an end to any continuing existing situation of occupation. So that's the status of the territory. But let's look in particular now first at Jerusalem and at what Israel did with respect to its legal rights to Jerusalem. Because Israel's Declaration of Independence from 1948 did not contain any reference to Jerusalem. It does not mention borders or territory specifically at all. Now, in December 1949, the Knesset decided that Jerusalem would be the capital of Israel. And on the 26th of December 1949, the Knesset held its first session in West Jerusalem, which had not been occupied by Jordan. In January 1950, the Israeli parliament again decided that Jerusalem, or declared that it would be the capital of the state of Israel. And when Israeli forces ousted Jordanian forces from East Jerusalem and the West Bank in the Six-Day War, ending on the 10th of June 1967, Israel immediately took steps to extend its law, administration, and jurisdiction over the whole of Jerusalem, using the terminology areas formerly part of Mandatory Palestine, which is particularly interesting when we consider the uti possidetis iuris principle and the grounding of Israel's borders in the administrative lines of the former Mandatory Palestine. Now, in July 1967, then Minister of Foreign Affairs Abba Eban informed the UN Secretary General in writing that these acts, Israel applying its law, administration, and jurisdiction to Jerusalem, did not constitute annexation because it came under significant criticism. In international law, we'll come on to the concept of annexation later, but you simply can't annex your own sovereign territory. So that is what I suggest was underlying Abba Eban's comments already over 50 years ago in 1967. Now, the Israeli Supreme Court has considered the legal status of Jerusalem, famously in a 1993 case, the Temple Mount Faithful Association and the Attorney General. And in that case, petitioners had requested the High Court of Justice to order the Attorney General and other Israeli authorities to prosecute the Muslim Waqf for having undertaken certain works on the Temple Mount without the necessary permits. Now, the High Court decided not to interfere with the discretion of the relevant authorities, the relevant Israeli authorities in this case, but it did emphasize that the Temple Mount is part of the territory of the State of Israel and that the sovereignty of the state extends over a unified Jerusalem in general and the Temple Mount in particular. So that's Jerusalem. This is a whistle-stop tour in the time available to us, but let's look at the issue of settlements. Because while we acknowledge the absence of an international consensus on a legal framework which properly addresses the territory, the principle, the application of uti possidetis iuris that I've described, while I will confidently sit in front of you and say there is no reason not to apply it to Israel, it does really seem from the rhetoric of the international community that an exception is being made to Israel. And the general principle of customary international law isn't being applied here. But I want to look on from that, in particular in the issue of settlements, to the Geneva Convention, and an argument which is put forward consistently in opposition to Israeli settlements. And when we talk about Israeli settlements, what are we talking about? We're talking about Israeli communities being built in the West Bank. Some of them were re-established on existing communities where the inhabitants had been ethnically cleansed by the Jordanians in 1948, and some of them newly established on state land. Some, to the extent that they are established on private land and illegally established, are generally removed where they conflict with the law of the State of Israel. But the argument that is advanced under the Geneva Conventions is one many of you may be familiar with. It's an argument under Article 49 of the Fourth Geneva Convention, which provides that an occupying power shall not deport or transfer parts of its own civilian population in territory it occupies. Now, it's on this basis that settlement policy has been criticised as a breach of international law by the International Court of Justice, the Security Council, the International Committee of the Red Cross, and various countries and international commentators. Crucially, I'd stress that none of the commentary or criticism, even from the International Court of Justice, has binding effect in international law. But still, there's a lot of it, so it carries sway. There are two substantial errors with this criticism. The first is the question of the applicability of the provisions of the Geneva Convention, and they don't apply outside of the context of occupation, and I've already addressed the status of the territory and why it is wrong to apply the framework of occupation or attempt to apply it in this case. But the second error relates to the mischief, which Article 49.6 was designed to counter, because this was an article that was drafted in the aftermath of the Second World War, and it was drafted in response to the forced transfer of populations by the Nazi regime. The full text of Article 49 prohibits individual or mass forcible transfers. Now, the article was directed against this heinous practice. It's clear that the entire article is concerned with forced transfer of populations against their will. And the last paragraph, paragraph 6, which relates to an occupier's own civilian population, must therefore also logically relate to forced transfer. And that position is reinforced when you look at the preparatory materials and the discussions behind the drafting of the convention, that this was to do with the movement of populations against their will. The application of this provision to Israeli settlements remains problematic, as the settlement movement concerns individuals and collectives moving voluntarily to the area after 1967. So the provision can't objectively be construed to cover voluntary movement of individuals, not as a result of state transfer, but of their own volition and an expression of their personal choice. But also, crucially, the restriction on transfer is a restriction on government action. It's not a requirement that government stop civilian movement into an area, although I should stress that on occasion the Israeli government has done exactly this, where it had a basis upon which to remove individuals settling on private land, as I previously indicated, those settlements that were truly illegal because they lacked the relevant permits, or they did not have a right to settle in terms of land law on the land itself. The spontaneous or voluntary movement of Israeli nationals simply doesn't trigger the text of Article 49.6. And the other aspect of this whole debate is that it's really instructive to look at the wider treatment of settlement activity. This has been the subject of a seminal piece of work and a great deal of detailed research by Professor Eugene Kontorovich. Does a lot of work in this area. And he's focused on it because, as I indicated, a fundamental principle of international law is its equal application. And he's shown that the international community has consistently acquiesced to government-orchestrated settlement activity in situations of real occupation. So not the situation that we have in the West Bank, but real occupation as contemplated by the Geneva Convention, and where government-orchestrated settlement activity forms part of the policy of the belligerent occupier. And I would love to go through in detail these examples. Time won't allow me, so you'll have to take my word for it that it has applied across East Timor, Western Sahara, Northern Cyprus, during the Syrian occupation in Lebanon, in Cambodia with respect to Vietnam, in Azerbaijan also, in terms of the Nagorno-Karabakh conflict, also in Russia's occupation in Georgia, Abkhazia, and in Ukraine, Crimea. In many of these circumstances, the settlement project is accompanied by other widespread human rights violations, and those have often occasioned comment by the international community that there has never been criticism of the settlement projects in these cases in terms of Article 49.6. So if in none of these situations settlement activity is criticised as illegal, and I indicated it's not the case that the activity has escaped international attention, in many of these cases there has been other criticism. Crucially, the failure to raise legal objections where it's consistent and general across all of these examples and extends to international organizations and groups like the UN Human Rights Council, the International Committee of the Red Cross, and humanitarian NGOs like Human Rights Watch, whose work it is to systematically point out violations of these norms. The lack of an international response here has the effect of legitimizing a policy of government-orchestrated settlement projects. And this is crucially because the development of international law, public international law, through custom is rooted in the practice of states, because it's their practice over time that results in that binding customary international law that I discussed right at the beginning. And when we consider that the only example in international law where the issue of settlements has been criticized as illegal is with regard to Israel, I think we have to consider whether the motivation behind that criticism is in fact political rather than legal. Now, finally, I promised that I'd come on to this example, this case study of the recent proposals which have been shelved of the Israeli government contemplating the application of civilian law to areas of the West Bank, parts of Area C in the West Bank. And it brings me in particular to the use of terminology, because the term annexation to describe Israel's proposed application of civilian law is wholly inappropriate, not just because Israel is the underlying sovereign, as I've previously indicated when we're looking at the status of the territory, but also because it's a misrepresentation of what is being proposed. So I'll give you the definition of annexation from the Oxford Encyclopedia of Public International Law. Annexation means the forcible acquisition of territory by one state at the expense of another state. So annexation is about taking for yourself territory belonging to another state. It's what Russia did in Crimea in 2014. It's what Germany did in Austria in 1938. It's what Jordan tried to do in the West Bank between 1948 and 1967. Now, opponents of Israel who use the term annexation make a series of false assumptions. They assume that Israel lacks a claim of sovereignty to the area. They assume that another state actually holds sovereign title to the territory. And they assume that when Israel applies its laws, it will be taking some other state's territory. Now, it's unfortunate that the terminology of annexation is being wrongly deployed here. And it really is an example of where the rhetoric of international law conflicts with the reality of international law, where a rule is made up in distortion of international law against Israel. And that is why you don't see such rules being applied anywhere else. The administrative regime that Israel established in 1967 in the West Bank was intended to be temporary because Israel recovered that territory from Jordan, but it was anticipated, it was hoped by Israel that a negotiated peace agreement at the time with Jordan would swiftly be achieved. And with that, there would be anticipated an element of change to sovereignty, change to borders as part of a negotiated settlement. That is why Israel applied a temporary framework 53 years ago. 53 years later, it is entirely unreasonable to expect Israel to maintain a situation of limbo, a situation where Knesset legislation does not apply to these areas properly, where there is therefore a devastatingly confusing patchwork of legal administration. You have leftover Ottoman law, Jordanian law, British mandate law, and often utter confusion at how these regulate 21st century issues, where there is a total absence of environmental legislation and the sorts of provisions which benefit the rest of the country, where civilian law is applied in full. So, the proposal of applying Israeli civilian law to these areas really brings with it, would have brought with it, benefits to the local population in terms of the consistency of the application of law, including Arab inhabitants, because, and it's also not been the case, I know, it's straying slightly from the legal aspects of it, but I think it's important to note that it wasn't the case that ordinary Palestinian Arabs who might have been impacted by these proposals necessarily opposed them, because they stood to gain substantially in terms of access to healthcare, access to the welfare system, access to social security benefits, the right to vote in municipal elections, and other rights that attach to residency. So the rights that even non-citizens of Israel, but residents in East Jerusalem benefit from, including the possibility of acquiring citizenship, and therefore all of the rights and benefits that attach to being a citizen of the only democracy in the Middle East. The practical implications of the proposals were also terribly misrepresented. There was this idea that it would be a prejudice to what a final settlement would look like. Of course, any proposals around a two-state solution have envisaged sovereign Israeli territory being transferred via land swaps. Most recently, the Trump plan envisaged significant parts of the Negev being transferred in that fashion. So in that sense, it did not affect the situation at all. Israel was still able to negotiate over territory to which its law applies, and it has done so in the past. Now, there is a significant caveat with respect to everything that I have covered with respect to the status of the territory. And you will have seen that what I've done is go to the starting point, the birth of the State of Israel, to determine what international law says about the territory at that point. And that's crucially because that's the way that international law is applied in these situations. But that is in no way to prejudge what a peace solution, a peace settlement would look like between Israel and its neighbors. It's not to say that the West Bank in its entirety must remain Israeli sovereign territory. Indeed, there is also a strong argument to say that arrangements and agreements that Israel, the State of Israel, has entered into, notably with the Palestinian Authority through the Oslo peace process, which divided the territory. And at this point, it might be helpful if I briefly switch to another map so that people have an idea of what it is when what it is people are talking about when they refer to areas A, B, and C. I'm pausing just to get rid of an echo, which seems to have gone. But you can see on this map the division between the areas of Palestinian entire control, which have the big population centers, the big Palestinian population centers in them in yellow. And in terms of Area C, which is parts of Area C with respect to the proposals of the Israeli government concerning application of civilian law, as I've been discussing, that is in this slightly lighter blue colored area. So the Oslo Accords are just an example of the sort of international agreement which can change, arguably, the status of the territory. But when we're looking at the allegations that are made with respect to Israel's illegal conduct, alleged illegal conduct, the crucial thing is to go to the starting point and work out what the original status of the territory is. And it's on that basis that I believe we can successfully begin to dispel those myths. This has been a whistle-stop tour through some pretty complex areas of international law and political history, but I hope it starts to paint the picture of how terribly international law is misrepresented in relation to Israel. And on that note, I look forward to your questions.
Thanks a lot, Natasha. Any questions from the audience? Please come forward, like we did in the last session, if you have a question. Yeah, please.
Thank you for a very instructive presentation of international law, or a body or a part of international law as I understand it. State law, state international law. To my knowledge, there are other elements of international public law that deals, for instance, with minority rights, different groups within the territory, and that. Would those other parts of international law influence your evaluation with regard to this state public international law, as I may label it? Thank you.
So the treatment of minorities rests on a question of government action and government responsibility. And in answer to your question, the position of the State of Israel with respect to everyone living within it, so this is Israeli Arabs after 1948, those that remained within the State of Israel became citizens of Israel and benefit from total equality, civil, human rights, political rights, and have formed a major contribution to Israeli society and Israeli successors. The minorities in Israel are unique in the Middle East in that their rights are protected. And also with respect to Christians, it's I think, a particularly instructive point that whereas the Christian population in the rest of the Middle East has been going down at an incredibly worrying rate, it has actually been increasing in Israel and in Israel proper. Unfortunately, in Palestinian Authority-controlled areas, the increase mirrors the decrease mirrors the decrease in the rest of the Middle East, for example, in Bethlehem. But in Israel itself, minority rights are prized and looked after. And certainly from my time working at the Supreme Court in Israel, I served as a foreign law clerk to the former president of the Israeli Supreme Court, Chief Justice Miriam Naor. I know that international law and international conventions, to the extent that they apply to Israel, play a very important part in the legal makeup of the country and the legal frameworks that are considered. And in fact, Israel is recognized as quite a forward thinker in terms of the incorporation of international legal frameworks into the decision-making of domestic courts. So I hope that that goes some way to answering your question. Yes, the protection of minority rights plays internationally plays a very strong and important role within Israel, but that aspect of law doesn't impact in any way on what you call the public international legal principles, which concern the status of territory and the delineation of borders and the sort of more state-orientated and sovereignty questions that we've been discussing in this talk.
There are no other questions. People have traveled far today and they are tired. And some of them are also signed up for a tasting of Israeli wine. and if you had been here, you could have joined us. But thanks a lot. We look forward maybe to have you come to Norway when all the pandemic is past us. And all the best in your great work in UK Lawyers for Israel.
Thank you so much. I shall see you tomorrow for our BDS and lawfare session, but it has been a pleasure and also a wonderful treat to see people in a room in person together. Hopefully a sign of things to come for us all in a not too distant future.
Yep. Great. We will see you tomorrow, like you're saying. So, bye-bye.